Right. Thank you very much for that. So let's start off with today's session. Before I begin, let me just quickly run through today's quick agenda so that we can actually know how the event will be run today. So the first off, we will actually be having a quick introduction of Circular Business Association, and then an open presentation by myself, followed by a presentation by Mr. Matthew, and then a presentation by Mr. Lewis. And then we'll move on into a moderated Q&A session. So if you do have any questions for our speakers, please drop it into the chat with the title question, so that it's easier for our team to actually pick up your question. Okay, while this session is recorded, the Q&A session will not be recorded. So please feel comfortable to ask any clarification questions that you may have in relation to the topic that we have today. And then last but not least, there'll be a quick closing from my end, and then we will move on with that. All right, so let's start off first with a quick introduction of Circular Business Association. So Circular Business Association, we are actually one of the leading ecosystem builders to solve the climate crisis. And we function to basically pull together all the different types of suppliers, vendors, and talents in order to make that journey towards solving the climate crisis much smoother. Our big why is that we're here to solve the climate crisis and create a livable world by accelerating business transition into a profitable circular economy. I've just realized that part of my slide isn't showing fully. I'm just going to quickly stop share and actually reshare my screen. Thank you for your patience on that. Now, Circular Business Association, we actually started in 2022. So we're just 3 years old as of last month. So we actually registered in Malaysia, but in any case, we actually function globally. Our challenge is to actually try and rapidly replace all linear economy products with circular economy products in the next 4 to 5 years. And what we essentially do is that we solve this question of who when it comes to delivering on climate commitments and sustainability commitments, because there are nations, there have been economic regions, private companies, or even financial institutions that may already have said we're going to have these climate and sustainability commitments, but who on the actual ground can actually deliver it for them? And that implementation gap comes with this ecosystem that is profit-driven and it's sort of like anchored with the circular economy in order to fill in those gaps. So at Circular Business Association, we've been very happy to share that we have already 2 approved communities that have been featured in the Climate Tech 100 feature. We've also had our honorary advisors who have been part of the top investment banking service provider in APAC in 2024. Another approved community bagged a global prestigious award for their leadership in sustainability. As well as you can see here, I have been appointed as a jury for the 2nd year running now for our Circular Economy Awards, starting in the Gulf cooperating countries in the Middle East, but now it's expanding globally. And last but not least, we also have our ESG Ready certification program, which fills in the gap to actually ready more businesses in order to deal with the pains of mandatory sustainability reporting, mainly focused in terms of the supplier and vendor level, not so much on the ones that are actually doing the reporting to regulators. So for those of you who actually don't know me, my name is Li Jin. I'm the chairperson of Circular Business Association, also the lead trainer for the ESG Ready certification course. Before I actually embarked on this part of the journey, I had 12 years experience of working in a economic and planning consulting firm that worked mainly to deliver programs and reviews, as well as surveys for the national governments, as well as multilateral organizations such as the United Nations country teams and the United Nations Development Program. In fact, I was very lucky to actually be part of the teams that was writing the final Millennium Development Goals report for Malaysia back in 2015, and also a part of the team that was writing the first voluntary national review and the first phase of the Sustainable Development Goals action plan for our nation. My experience actually builds on a number of different credentials. It includes the IFRS FSA credential. Now I'm a level 2 candidate, which means I've already passed the first level of this professional paper on sustainability reporting. I also have a background in environmental economics from Cranfield University, as well as environmental science background coming from Monash University. All of that becoming part of my experience, as well as being supported by the Chevening Scholarship. Now, today's topic in the webinar is something that's very interesting for me, even though I may come from more of an economics and science background, because back in 2020, I was actually invited by the Bar Council of Malaysia to be one of the non-legal content providers to curate a series called the Bar Chats Enviro Rights series, which is a 5-part series available on Spotify to talk about environmental rights. And at that time, what prompted that action was the case of the Sungai Kim Kim river pollution that caused a number of schools as well as local factories to actually close down because the pollution was so bad. And that actually got the, I think, at least for me as a layperson at that time, it was the first time I actually saw such a big environmental case splashed on the front pages of all our national newspapers, and that there were actually lawyers representing different victim groups to actually sue the various parties involved in that. So that actually prompted a lot of interest from my end to explore further this area. But before I go deeper into that and introduce you to our special guest today, Mr. Matthew, to talk deeper in terms of the law perspective, and Mr. Lewis to talk more about how to actually monetize and finance these ESG litigation related cases, please allow me a few more minutes to actually talk about the rise of ESG as something that is not just like a trendy sort of thing, but it's actually very much gained momentum over many years. Now, if we look at the global ESG and sustainability consulting market, it is at US dollars 9.49 billion as of 2022 and set to reach 16 billion by 2027. If we look into the global climate tech market, it's valued at 20 billion US dollars in 2023, which is up 22%. And between now and 2030, the circular economy has estimated the market value to be 4.1 trillion euros. Over 167 trillion US dollars is also estimated for ESG investing by 2034. It sounds like a big number, but actually we're quite close to actually reaching that year, right? So when we start looking into these various things, a lot of people think ESG is just recent, it's just something that appeared recently, but that's actually not the case. Now, its history actually has built in momentum over many years with some key dates in 1945, 1991, and of course the 2000s, where we start seeing that the United Nations actually coined and sponsored a lot of these reports on environment and development, because they were realizing that without the right social justice and distributive policies, global economy was viewed as an impediment, right? It was actually causing conflict. So there was a lot of effort from that aspect to actually pull together this dual, or let's say mutual goal between business, the capital markets, as well as the development perspective. So it started shifting in the 1990s towards something that was mutually supportive, where you could achieve business goals while also achieving the UN principles to allow development to be more sustainable in that sense, that it wouldn't lead to large inequalities, where both in wealth, but also in terms of access to various services and needs. It would also allow businesses to participate by bringing in the type of resources into solving a lot of the challenges in the development scene. Now, in the 2000s, though, there was a major sort of shift, or let's say the late 1990s, so it was 1998, 1999, we started to see a major shift in that direction. And in the 2000s, the Voluntary Global Compact was actually operationalized. And then later on, sort of midway into the 2000s, the term ESG was formally coined in a report. Of course, as you know, in the 2010s, these two major things in ESG actually happened. The first was that 169 countries actually signed on the Paris Agreement on climate change to actually acknowledge that this was a big enough issue that required everyone to actually have some parts legally binding. And therefore try and solve this climate issue that we were facing together. In the subsequent year, which is the 2016, we saw Sustainable Development Goals come into play, and that actually started to set the vision in terms of what sustainable development looks like. And there are 17 different goals to describe it, 169 different targets, and 269 indicators to actually tell us what sustainable development goal would look like. And again, this was signed on by more than 160 countries globally. So these two drivers have actually sort of like been holding a number of national and international discussions over the years since they've been signed. But interestingly, in 2024, I think that was a great turning point because we actually moved from voluntary reporting into the era of mandatory sustainability reporting. Now, a lot of people think that mandatory sustainability reporting is still about all the sort of like CSR, charitable causes that a company is pursuing. But looking at the adoption of the global baseline methodology, it's actually looking more in terms of needing companies to mention what sort of risks and opportunities that is related to sustainability that's causing an impact to assets, liabilities, equity, income, and expenses, right? So there's a big financial impact part of it that needs to be linked to those sustainability issues. It's not just talking about the sustainability issues or saying that we're doing this program, that program, that's not directly linked to the business. There needs to be some form of financial impact before that sustainability issue would be considered material and therefore needs to be reported. Why? Because this mandatory sustainability reporting is essentially being targeted towards a group called investors. And essentially it means people who are making decisions on whether to provide resources to a company to pursue their operations. All right, so if you are interested to learn more about this, our ESG Ready certification course looks into this, especially in level 2, where we're talking about using data preparedness to meet these mandatory sustainability reporting claims. In any case, it's not just happening in Europe where some standards like the IFRS is being adopted. It's also been used as the baseline for big markets like China. Of course, there will each country will add on a bit of their own requirements, but we also see the baseline, the IFRS ISSB standards being used also in Singapore, where it's not just public listed companies, but even large non-listed companies need to disclose. The same goes for Malaysia, that's also adopted the IFRS standards and also targeting public listed and non-public listed large companies. We've seen the same thing in Japan, and there are many other countries in the world that's already decided or already taking steps to use this global baseline framework in their direction. Now, a second big thing that actually happened in 2024 was that the accumulation of litigation cases relating to climate and ESG has also increased a lot. In fact, since 2015, these cases have increased by 70% of these cases actually happened since 2015 when the Paris Agreement has been signed. And you can see it's not just happening in the so-called Western countries. There are a lot of other countries that have already seen cases being brought to courts across the world. And this actually really piqued our attention because this topic actually talks about greenwashing as a gold mine for litigators, which means that it's not just about, feeling good and all that. There's actually profit to be made by getting into this space. And that 70% of these cases tend to favor the claimants, which means that if you're a company being sued for climate or ESG, the chances of you winning might be pretty slim. Now, a lot of people think that you need some sort of greenwashing law before you can do anything, or maybe some sort of like corporate directive before regulators or other people could bring you into legal action. That's not actually been the case, because in 2024 and 2023, we actually saw a number of cases which use different types of laws to actually take action on companies. This includes advertising laws, market authorities, competition authorities, trademark laws, consumer protection laws, and even financial conduct authorities. This is an example in China, whereby if you did have any of these type of trademarks, you would already be sort of taken on legal action, because by design of this trademark, you might be deceptive in nature and lead to mislead public into the characteristics of your product. So why is all this happening right now? It's because we are facing a triple planetary crisis. So the physical world around us is putting some pressure onto us as a species, as humans. It's not just climate change. There's also a biological loss in the diversity that we have in the world, which means we have less options when it comes to adapting to big changes. And also the pollution crisis that's actually happening. And climate change alone could cost governments 38 trillion by 2050, and governments wouldn't want to go to there because it could lead to a lot of conflict. The warning, though, is that it's not that we don't have the know-how, it's not that we don't have the money, it's that the pace and scale of action is still insufficient. And if we were to follow the scientific deadlines that have been put forward, which is 2030, is the point of no return, and therefore the whole climate system is locked in. Even if later on we were to reduce emissions, we would have already locked in a lot of these different effects already, which means our operating system, like our phone operating system, is already locked into a high stressed sort of world. We're talking about water stress, we're talking about food disruptions, crop failures, such high temperatures that people have increased heat waves and dying in their home because it's just too hot, as well as a number of key sort of like cooling mechanisms that our ecosystem, our natural world actually has being turned off, which means that it will only get warmer and warmer and warmer, leading to also disease spread across different geographies. Places that before you may not have had, let's say, dengue fever, may actually now have dengue and malaria because it's just warm enough now for the breeding. So it's not just about carbon, they're key pollutants. These planetary boundaries, as you can see, is being exceeded a lot across the different sort of realms that keep our natural world functioning the way that it is. Secondly, a lot of nations are starting to get sued. I think Matthew will cover this in more detail later, but essentially this was a landmark case, again, that happened in 2024, where a group of women actually managed to sue their government for not doing enough on their climate policies. There's currently a landmark hearing on climate change in the world, whereby countries are actually seeking the International Court of Justice to make a stand or clarify what it means to actually protect the climate systems and what's the legal consequences of not acting on it. We've also seen the Global Plastics Treaty last year being held. Yeah, this actually is something that is pretty big because it could actually start the movement towards solving key pollutants right from the source and not just as an end-of-pipe solution. Last but not least, this is something that also came up in a magazine where strategic litigation is now being put forward for philanthropists, not just investors, but philanthropists shall actually finance because they are starting to see that that could actually lead to more systemic change happening faster with the using this additional tool. So without further ado, I'd like to invite our special guest, Mr. Matthew Kasdin, who is pioneering award impact lawyer and Legal 500 General Counsel and Green General Counsel Powerlist, to cover the topic of current legal topics in sustainability, climate, human rights, greenwashing, and beyond. Matthew also has previously served, or currently actually still serving as a lecturer in some universities, and he is also a Fulbright scholar as well. So with that, Matthew, you have the floor. I will stop sharing now.
Okay, well, thank you for the nice introduction and fantastic set of slides that you presented. Just trying to share my screen. Um, uh, let's see, did that work?
Nope, we can't see your screen yet.
That worked. Okay, sorry. So yeah, anyway, I'm Matt Kasdin. Yes, I was a longtime lawyer for the United Nations, and I work for a big law firm. I moved to Singapore about 15 years ago to get involved in impact investing. And I've been involved in impact investing in renewables. Can you see my screen now?
Yeah, we can see a screen, but not yet full screen.
Is it full screen now?
Yeah.
Okay. Okay, good. Yes. So this is me. So yeah, I'm Matt Kasdin. I've been in Singapore now for about 15 years. Originally from Oakland, California, qualified to practice law in New York. I practice at one of the biggest law firms in New York. Also at the United Nations, I was the general counsel of the Global Compact, which Lee Jun mentioned in her presentation. Also, I wrote the Constitution of the PRI, which is the world's biggest investor initiative with about $120 trillion under management signed up for that. I've also worked in UN courts in The Hague. I teach at SMU, and I'm also affiliated with a law firm and have an ESG consultancy. So I have a lot of hats. One other thing I thought I'd mention to this group, because there's a lot of Malaysians in the House. I have spent a huge amount of time in Malaysia for the last decade. And so the solar company Maxi and I was with, we had a factory in Malacca. So I've been up to Malacca many times. And then I've also participated with Forum for the Future last year in a 4-part workshop in Kuala Lumpur. So I was going back and forth all year on the treatment of migrant workers, which can be an interesting part of the ESG litigation landscape, as I'll get to. Because what I'm trying to do in this presentation is kind of think globally with all the trends, but then also locally and see how it affects companies here, and also see what enterprising lawyers could be doing to figure out if they wanted to get involved, either representing companies to future-proof them or representing interests that wanted to sue bad actors. So I'll provide a lot of information on that. I also spoke at the Malaysian Bar Association in Kuala Lumpur last year on ESG. Lee Jun has already given a great actually overview of the fact that there's a lot of different theories used for ESG litigation. So I think what I'll do is maybe just follow the way that we do law school in the United States, which is very much we learn by case law. I've actually, while Lee Jun was presenting a lot of information, I deleted a lot of my slides. It was kind of the introductory stuff. I actually had the same map as she did. And I'll just jump into some cases, which will help you kind of see about how this stuff works in action. So let's start out with climate litigation. The first one is a Dutch NGO suing the Dutch government. This case is actually rather like the one Lee Jun mentioned with the Swiss grandmothers suing. So this is a group suing the government for not doing enough to protect the country from climate change under a constitutional human rights theory that the government has a duty to protect its citizens. As we'll get to, this is also happening in Asia, and there have been lawsuits against both the Korean and Japanese governments brought by groups. As you'll see here, when we talked about the strategic litigation, a lot of these lawsuits are brought by NGOs who are very much trying to make a point, and they're funded to go after companies and governments. A lot of it's to get publicity, But now I think, as Lewis will get into, there are enterprising lawyers looking at it more as kind of a way to hold corporations to account in the purse and profit from it. So I think there's both sides of groups pursuing these litigations. The second case on climate litigation that I think is fascinating is this case of the Peruvian farmer. And this one just had some developments last week in Germany. And so the Peruvian farmer was a person going about his business farming in the Andes, and he had to protect his farm area from the rising floods. And he was able to show with his climate scientists that the rising floods, that he had to pay all this money to build this protective wall, uh, that these floods were caused by climate change. So he had some enterprising lawyers, and what they did was they figured out that there's an electricity company in Germany that's been belching out coal for about the last 100 years. And then they calculated that this electricity company in Germany was responsible for like 0.4% of all of the global warming to date. And so the theory was that they could go after this company. The farmer could sue this company for 0.47% of the cost of protecting against climate change. So this is one of these cases that was very much brought as a symbolic case. The actual amount of money, if you do the calculation, is maybe 20,000 euros. But they were actually successful in showing in the German courts that this theory could be successful, that companies could be held accountable for climate change by the people that are hurt by it. So this is one of the cases where it's kind of a strategic litigation where it's not so much the money at issue, but the principle. And then now that the principle's been established, now enterprising lawyers can jump in and make more sort of copycat cases to advance it, and maybe find cases where there's more significant damages. The third case study I have is in Australia, where a company in Australia was prevented from continuing to operate because they were at risk of forest fires because of the deforestation that they had there. So this is an example of courts going to companies and saying, hey, you need to stop doing that because it's going to lead to problems for the environment in the future. So it's an interesting one because the environmental harm or the climate harm doesn't necessarily need to have happened for the lawyers to bring a case. The next climate case that I thought was interesting to share with you was for myself. I wind up counseling boards of directors a lot, and I have a lot of closed door meetings with boards of directors to advise them of all the ESG risks. And so the interesting one about this case of the Polish directors is that the directors were actually held liable for violating their fiduciary responsibilities because what the directors did was they approved the company constructing a coal-fired power plant, and it turned out to be a disastrous decision because of the environmental laws. It wasn't going to be practicable, and the company had to write off about $250 million. And the interesting thing here was that the directors were actually held responsible for not factoring in climate change to their decision making. And so that's an important case for anybody that advises board of directors. Actually, board of directors are getting held accountable for not adequately addressing climate change. And then the last climate change case that I have for you, which, as I'll get to at the end, I think could be potentially quite interesting for people here in this region in Southeast Asia, is the case of the Brazilian beef. So there's a company in France that is called Casino. For those of us in Singapore, it's kind of like the fair price or cold storage of France. And people will go there and buy a steak and cook their steak at home. But the issue with them was that a lot of the beef that they were selling at the supermarket in France came from Brazil, and it was tracked down that the land in Brazil was actually on deforested land in Brazil, which constituted a crime. And so they're getting sued for millions of dollars now in the French courts for selling that was created on deforested land in Brazil. And what's interesting about this case is the theory about the deforestation, but then also the transnational nature of justice. Because I've been in Singapore now for 15 years, and a lot of people think, oh, people in Asia aren't as litigious. But this is an example of something happening in one place, and then they bring justice halfway around the world. So if someone in Malaysia or Indonesia was creating beef from deforested land in those countries, then potentially somebody could bring them to court in Europe on the same theory. So those are a few of the climate cases out there that I think are quite interesting to think about. And when you think about them, also to think about how could these cases be translated to what is happening here. And as Lewis will discuss, how to think about, are there cases that could be brought against companies for similar? So in Asia, I guess I've already mentioned that you have in Korea and Japan similar cases to the Dutch or the Swiss one with people suing the governments for climate change. You also have India, where they found the right to a clean environment to be constitutional. In Singapore, there was a case against PNG, Sustainable Development Program. That was a mining company doing business in Papua New Guinea. And so that was the most famous sort of environmental law case here. In that case, actually, there was a mine in Papua New Guinea that caused significant damages to all of the community around the mining site. And the company is called the Sustainable Development Program. It's in the name of the company. So the company was doing some greenwashing in terms of representing themselves and being sustainable when they caused a lot of damage to the community. However, Singapore courts were quite conservative, and they said that the company doesn't have any duty to the community. So that would be an example of a case where Li Jun had said that every plaintiffs will normally win these cases, not always. But it is interesting to see these cases happening here in the area. And then you also have, just to round out the picture, cases where the companies are actually going back and going against the activists who are suing them. So you have ESG backlash cases where companies are getting sued for maybe over considering the environment in decision making and under considering profits. You have what are called SLAPP lawsuits, where companies are actually suing the NGOs for trying to pursue them, to persuade them to stop bringing cases. You have just transition cases, which are challenging the distributional impacts on human rights grounds, and we'll get to more of those. And then you have green versus green cases, because not all green people are pursuing the same goal. So you might have one person pursuing climate change and one pursuing biodiversity, and they might actually have different agendas. For instance, if somebody wanted to be constructing windmills because they're going to prevent they're going to help for climate change because it's renewable, and then somebody else is trying to protect the birds that are flying into the windmills and getting killed, then those two groups could be against each other. So quite a complex issue. Then there's some future trends, a lot more post-disaster cases as there are more disasters happening. Criminal law, there was something that came down a couple of weeks ago with EU moving to make a lot of environmental crimes a lot more strict on the criminal side. And a lot of these criminal theories can actually even make the civil cases even stronger and the amount of financial award higher. And then you have synergies between environmental and climate litigation. So that's a quick overview of climate litigation. Now, I wanted to move on to greenwashing. In Singapore, and Malaysia has the same basic law, which is greenwashing is actually in countries that don't have greenwashing laws, which are most of them. Greenwashing currently is regulated under a number of different regimes. most prominently kind of false advertising, which is the Consumer Fair Trading Act or the Misrepresentation Act in Singapore. They've got the same act in Malaysia. I have actually got a friend who's a Malaysian lawyer who published an editorial a couple of weeks ago in the Malaysian press calling for a greenwashing specific law in Malaysia. But right now, you still do have these regulations that are applicable because if a company makes a false claim, that can be actionable, whether it's called greenwashing or something else, and you can bring environmental claims under these acts. So just a few greenwashing cases. The classic one is BP, which used to be British Petroleum and then became kind of Beyond Petroleum. So they were sued for misleading advertising. You can see that it looks like it's kind of a tropical garden when in fact it's an oil company in terms of their advertising. You do have a lot of funds getting sued for misrepresentation. That's happened in the EU, in the US. The one here I have here is in Australia. This was just upheld where a Australian fund manager marketed their fund as green or ESG, and it was found to be misleading, and so they had to pay a fine. Um, Another recent case that just came down in Australia that I thought was quite interesting. This one was brought under competition law principles by the Competition Law Authority, which is where a company was marketing its trash bags as like 100% recycled ocean plastic. And then somebody actually went and did the research, and it turned out that a lot of it wasn't actually ocean plastic from the ocean. It was plastic from Indonesia that was still on land that could have been destined for the ocean. But since it wasn't in the ocean yet, it was found to be misleading, and the company had to pay an $8 million fine. In Singapore, we also have our first case here, which is, forgive me, I'm not very good with pronunciation of Chinese names, but it's like Xiaoshui. It means snow in Chinese. She's a old school influencer. I think she's been around for more than a decade. But she was, you can see her advertisement here. You said she's here to save the earth. And she was advertising for an air conditioner company, and it was found to be misleading, and she had to take down the ad after it was complained about. So those are some, I think, interesting cases on greenwashing. Then you have human rights litigation, where considering it's a Malaysian audience, I thought it interesting just to talk about a couple of cases in Malaysia, which both have the principle I was talking about before, which is where the ESG litigation, you can have an abuse happening in one place and the lawsuit happening somewhere far away. So you have here, there's the Dyson case, where an English court is hearing a case brought by Bangladeshi workers at Dyson's Malaysian factory. And so they're actually bringing the case to the English courts based on human rights abuses in Malaysia. Similar theory in the US courts, Kimberly-Clark, which is a company that distributes to hospitals a lot of paper towels, toilet paper, that kind of thing, but then also the gloves, which Malaysia is so famous for making gloves. And so Brightway was one of the manufacturers, and so they're getting sued by a class action lawsuit brought by a bunch of workers in Malaysia, saying that they were mistreated in Malaysia, but the case being brought in the U.S. courts, and the U.S. courts globally are famous for having the highest verdicts of any place. So that's a quick sort of roundup of some of the litigation ESG happening around the world. I did want to leave a lot of time for questions. So just leaving you with a couple of different trends here about things that I see for the climate change. I think there's going to be more and more cases for the deforestation. I didn't go into detail on it, but the case I mentioned in Brazil relied a lot on satellite imagery from NASA and all of these tools that are getting much more sophisticated. So to the extent that somebody's deforesting land in Indonesia or Malaysia or Philippines or somewhere, it's becoming much more easy to show what happened. And with this evidence, then it becomes much easier to bring it to court. So this is the evidence being relied upon in the French courts. And I do see, to the extent that there's deforestation or other environmental damage in Asia, that could be a big trend of finding environmental problems in Indonesia and then finding a way to have plaintiffs in the US or Europe bring the case there, where the sort of deep pockets slash legal system conducive to the claims, where you get kind of the perfect storm that makes it a good place to bring an environmental claim. For greenwashing, the case I just mentioned, Indonesia, I think is a line of sight for a lot of companies that are making claims, just going and digging into, on the ground, are these claims actually true? And if you find out they're not true, then there could be a gold mine there. And then I think those two cases I just mentioned in Malaysia of the Dyson and the Kimberly Clark are cases that can be replicated quite a bit in the British courts and the American courts. The Dutch courts are also very receptive to ESG cases. So right now, those are the three main jurisdictions to target for your cases. So that's all the prepared materials I have. I'm more than happy to continue this discussion. I think there's going to be some networking, some time for questions. Also happy to answer questions on LinkedIn or whatever. So thank you for coming, and look forward to continuing the session.
Right. Thanks very much, Matthew, for that very interesting set of case studies. Just now, as you were talking, it just reminded me of like when you're talking about the satellite imagery, that the United Nations, as well as a number of various foundations and trusts, actually have launched this thing called methane sat, whereby they're using satellite imagery to create fast, free, and transparent data, actually just on the pollutants of methane gas, to bring a lot of big emitters, make them visible. And it also brings back to this whole thing about beef being one of the major sources of methane, apart from that, landfills as well, being something that is going to be huge in terms of methane emissions. So yeah, I think like your presentation really sparked a number of questions even in my mind. I'm holding out till the moderated Q&A session. But for now, I think this question actually does emerge in my mind as to whether or not the question of, will lawyers actually become the spanners locked in the gears, or will it be something that actually becomes the lubricant oil that allows a lot of these climate action, environmental action to move in the right direction so that we can solve the climate crisis and our triple planetary challenge, so that we can actually, as a species, survive. So with that, I'm very happy now to move on to our next speaker, which is Mr. Louis Chung, the Senior Managing Partner of ACMF International Private Fundraising. Louis is a seasoned professional with a passion for sustainability and is a group chairperson for ACMF Group of Companies that provides international private capital raising, sell-side merger and acquisition services with a footprint of over 10 countries. He also co-founded the Circular Business Association back in 2022. And one thing that people don't know about him is that he actually retired in 2012, but due to his passion for solving the climate crisis, he started Climate Movement 2.0 and came back to the business world in 2015, when his friends would call him crazy, but now they call him visionary. The impact-driven co-founders that Louis has co-founded ACMF with, and also the shareholders with, actually come from corporate backgrounds, including venture capital, investment banks, capital market regulation, private equity, and national climate policy. So with that, I'll pass the floor over to Louis for his session titled ESG Monetization and ESG Litigation Funding. Louis, over to you.
Thank you, Legin. Good afternoon, everyone. I'll cover the topics of ESG monetization and ESG litigation funding. I'm from ACMF, so core business mainly around area private capital raising. Means help companies to get fund from qualified investors in Asia, Europe, Middle East, and North America. My sharing will be very short, but very much focus on why ACMF companies think ESG is going to be a profitable industry, and how we intend to involve in ESG litigation funding. So why we think ESG is going to be a profitable industry is that according to survey, over 75% of consumers will stop buying from companies that neglect ESG. And over 85% of consumers want to engage with companies that are more committed to ESG. And over 9%, even 9% of consumers would pay higher price for products that are more ESG. And small, medium enterprises that were implementing ESG practices had a 20% increase in their revenue. So the ESG investing market size is going to be quite big, over 160 trillion US dollar. And December last year, for the first time, we come across this new thing, like suing companies and governments agencies for their ESG violation have started to become investable investment. So we have over 10 fund arrangement teams regionally, and they have roughly checked with their investors about investing in ESG litigation funding. And surprisingly, over 70% of them are willing to evaluate these investment opportunities. So, but not to disappoint anyone, ESG litigation funding is still very new to ACMF companies. We are very much we're still testing out the investment thesis with our investors. So we have identified a few parameters about qualifying these investment opportunities. First is a non-recourse investment. That means the investees do not need to pay back the money if they lost the cases. And the investor only share the payout from winning or settlements of the cases. So non-recourse. And even though it's called ESG litigation funding, we are also open to arbitration cases as well. And the other test is called media front page test. It means the case must make the investors look good when a disclosure is needed. Minimum payout 5 million US dollar. The more is merrier. Because the investment institution fund we are dealing with, these are people can invest up to 200 million or more US dollar. The duration from first injection of fund to the payout is ideally within 3 years and not more than 5 years. The other test is called collectible. The defendants must have the ability to pay. Okay, so investors, they are not. The reason they invest because they want a good return, a reasonable return. So for ESG litigation funding projects, we will deal with lawyers only, because ACMF companies, we are not legal experts. So to qualify suitable investment projects, initially we need some non-proprietary information about the cases. So we need to know the nature or type of ESG violation. For example, is it about water pollution, hazardous waste disposal, illegal logging, greenwashing, or other type of ESG violation? And we also need to know the geography of the violation and how much investment is needed and the potential payout. We do not want to know the names of the claimants and defendants during phase 1. And so when you have this detail, feel free to email the non-proprietary information to ESG litigation funding at acmfgroup.com. So we have colleagues in over 10 countries that help us to process the cases. Okay, thank you. That's all from my side.
Thank you very much, Louis, for sharing that. And it's great to actually hear that there is interest of investors actually put in the money so that these cases can actually be brought to light. On that note, I'd like to, I guess, open the floor for the Q&A session. At this point, I'm going to stop the recording so that it's comfortable for everyone to actually ask the questions that you may have. Now, if you do have a question, please actually raise your hand, or you can actually put it into the chat group titled question so that the team can actually pick it out. So I'm going to pause the recording